Sit down. Thank you, but now I don't know whether you'll mean it when you give me a standing ovation after. It's like I haven't done anything yet.
So good afternoon, everyone. It is a great honor to welcome you to the Howard J. Trienens Visiting Scholar Lecture with U.S. Supreme Court Justice Elena Kagan. I'd like to give a warm welcome to some special guests who are here with us today. We're very honored to be joined by members of Justice Kagan's family, Irv Kagan, Allie Kagan, and Benjamin Kagan. We are also honored to be joined by Nan Trienens Kaler, who's the daughter of Howard Trienens, and Newt and Mary Minow, as well as members of our judicial branch and a number of university leaders. I'd also like to just take a moment to thank our law school team for their wonderful work in bringing together today's events. Since 1989, the Howard J. Trienens Visiting Scholar Program has invited a leading jurist to Northwestern Pritzker School of Law to lecture and offer alumni, students, and faculty with a perspective on the judicial process and contemporary legal issues. The program was established by partners of Sidley Austin LLP to honor our esteemed alumnus, Howard Trienens, in recognition of his service to the firm and to Northwestern. Mr. Trienens joined Sidley in Austin in 1949 as an associate, became a partner in 1956, and headed Sidley's executive committee from 1977 to 1993. He also had a very long-standing relationship with Northwestern University. He received his bachelor's degree here in 1945 and his Juris Doctor from Northwestern Law in 1949. He was a member of the university's Board of Trustees since 1967 and chaired the board from 1986 to 1995. Mr. Trienens passed away at the age of 97 in the summer of 2021. His daughter, Nan, is here with us today representing the Trienens family, and I want to extend my gratitude for the leadership and the generosity that her family has shown to the law school and to the university for so many years. And now I have the tremendous honor and pleasure of welcoming U.S. Supreme Court Justice Elena Kagan as this year's Trienens Scholar. She was also the Trienens Scholar in 2015, and we're just delighted to welcome you back. It's particularly special to have you with us on this day, and when we're also honoring our alumnus, Justice Stevens, who you succeeded on the Supreme Court. Justice Kagan's visit is a wonderful opportunity for our community to learn from a path-breaking legal leader who has made extraordinary contributions as a legal scholar and law dean and through public service. For me and so many members of our Northwestern community and our society, Justice Kagan has been an important role model. Justice Kagan was born and raised in New York City and graduated from Princeton University, the University of Oxford, and Harvard Law School. After Harvard, she clerked for Judge Abner Mikvah of the U.S. Court of Appeals for the D.C. Circuit, and then for Supreme Court Justice Thurgood Marshall. After working in the Washington, D.C. law firm of Williams and Connolly, Justice Kagan then became a professor, first at the University of Chicago Law School and later at Harvard Law School, and made important scholarly contributions to our understanding of the administrative state and interbranch dynamics. He also served for 4 years in the Clinton administration as associate counsel to the president and then as deputy assistant to the president for domestic policy. Between 2003 and 2009, Justice Kagan served as the dean of Harvard Law School. And in 2009, President Obama nominated her as Solicitor General of the United States. A year later, the president nominated her as an Associate Justice of the Supreme Court, and she took her seat on August 7, 2010. We are so honored to have the opportunity to dialogue with Justice Kagan today and hear her insights. Please join me in welcoming her.
Thank you. Thank you very much, Dean Osofsky. Thank you to all of you for being here. It is my second time as a Howard Trienens Scholar. So I must like this place. I know I respected Howard Trienens enormously. The last time I was here, he was still alive. He was a great legal leader. I mean, obviously, his role in shaping Sidley Austin and making it into the global law firm that it is today. I got to know him a little bit even before I came here in 5 or 6 years ago, because as Dean Osofsky said, I started out my teaching career at another Chicago law school. And people in Chicago, they just knew who he was. You know, he was so important, not only to that firm that he developed, but to this city, and was such a leader in this city. And what I like, when I think of Mr. Trienens, I think of like a problem solver extraordinaire. And these are the best kinds of lawyers, right? The lawyers who solve problems. So that even in the big cases that he did, the big litigations, I mean, some of what he was best known for was actually the settlements that he reached in the end, settlements that set the rules for entire industries, or he was a person that in the end wanted to get things done, and wanted to get things done in a way that satisfied as many parties as possible, and he wanted to solve problems. And it's a great model for lawyers, and especially for young lawyers of the kind who are in the audience today. So it's a real honor for me to be here.
Well, thank you, Justice Kagan. And this is sort of a perfect lead-in in some ways, talking about what matters in how lawyers practice, to ask you what inspired your interest in law, and how that interest has evolved over the course of your leadership roles as Dean of Harvard Law School, Solicitor General of the United States, and Supreme Court Justice, which have obviously provided you with a variety of vantage points on our legal system.
Yeah, I'm not exactly sure. The question of what inspired my interest in law, I think I went to law school before I knew the answer to that question. I was once, I was a dean like you, and I was once talking to a group of admitted students, and I said something which is a very standard thing for deans to say about how you shouldn't come to law school if you don't know why you want to go to law school, and don't come just because it's a way of keeping options open, and don't come just because you've sort of ruled out everything else. You're not good with blood or whatever. Like have a reason for being here. And I went through this whole thing, and I thought, I definitely failed that test when I went to law school. I think I went to law school because I wasn't sure what I wanted to do, and I wanted to keep my options open. My father was actually a lawyer, but at that time, and it shows that we have immature times in our life. I didn't really quite understand why it was important, or what he loved being a lawyer, but I wasn't quite sure I understood why. Nothing that he did struck me as so particularly interesting. So I was there really, truly at law school for the wrong reasons. But I'm here to say, and I hope I'm talking to a lot of first years in the audience, people who are here in their first week. I walked into Harvard Law School and I loved it, and I just loved thinking about law, and it has this kind of, I think it's analytically fascinating, so it appealed to the part of me that just likes, the part of me that likes, doing analytic puzzles, if you will. But then, of course, it's also, you can make a real difference thinking about law and doing law, so you can make a real difference in the world. So it appealed to both sides of me, the kind of, like, I just love solving analytic problems, and the kind of, I want to make a difference. And I saw that pretty early on in law school, and I've been really fortunate, really blessed to have a career where I ended up in some important roles.
And clearly ones in which you could be making a real difference. I wanted, since we're honoring Justice Stevens today, to ask you a little bit about your predecessor on the court. And in particular, I mean, he was a dedicated alumnus, dear friend of our law school. And so I wanted to get a sense of what you learned from him during your transition to the Supreme Court and how you would describe him personally and as a justice.
Yeah. So I think that the first thing that comes to everybody's mind when they talk about Justice Stevens is independence. You know, he was a person that he followed his own course. I think at the beginning, when I clerked at the court, he was on the court when I clerked on the court, and he hadn't been there for many years. He had been there for only a few years, maybe 3 or 4 or 5 or something. And I think at that early stage in his career, there were some people who sort of thought of him as a little bit idiosyncratic, like he would write these opinions just for himself, and they weren't really what anybody else was thinking about. But I think it was actually a great marker of the justice he was going to turn out to be, because he really, you know, followed his own star, and, you know, he didn't seek approval from anybody else. And if he thought something was right, it didn't matter whether, you know, however many other people thought it was right. I mean, he was really very committed to thinking through a problem independently and telling you what he had come out with. So independence, first and foremost. Second, I guess, is just brilliance. When Justice Stevens passed away, his family really honored me by asking me, and because I was his successor, to make some remarks at the Supreme Court portion of his funeral. And the way the ceremony was constructed, there were just a ton, there was limited spacing within the Great Hall, and there were a ton of his clerks there, because by that time he had had an enormous number of clerks. And I remember that one of the things that I said, I looked around the room and all his clerks, and I said, you know, he really didn't need you. And it got an enormous laugh because it was obviously true. That he was so brilliant. He was such a, you know, he wrote drafts himself. He wrote, he liked having clerks around to kind of check his work a little bit, and clerks are good for that. But he was so reliant. He was so brilliant. I mean, it's so fast in everything he did. It's sort of, when I clerked for the court again, Justice Stevens only had 2 clerks because he thought, like, who needs more than that? You know, everybody else had 4, he had 2. And he was, you know, and we wondered what they did really, you know? So I guess that's the second thing to say about him. I think the third thing to say about him was what, like, a fundamentally decent human being he was. I mean, when you talk to all those clerks, and when you talk to anybody who knew Justice Stevens, I mean, there was such a kind of kindness and generosity. I experienced also a sort of politeness. I experienced this because I never served with Justice Stevens, obviously. I succeeded him, but I argued to Justice Stevens when I was Solicitor General. And you would always get, Justice Stevens started almost every question by sort of looking at the lawyer, and often he would come in at the end of an argument and he would say, you know, General, you know, or counsel, may I ask a question? I was like, no, you know. May I ask a question? And you would, of course, say, you know, yes, Justice Stevens. And then he would ask this rapier-like question that would just, you know, skewer you, right? And so I love that about Justice Stevens too.
And so what was it like to succeed him on the court then?
Well, it was sort of daunting, actually, yeah. I think, you know, I've been thinking about this a little bit because the court is changing again. Justice Breyer has left. Justice Jackson is taking his place. And every new justice, in some sense, creates a new court. And partly it's because of that justice. And I'm sure, you know, Justice Jackson is going to be a fantastic colleague and is going to bring all kinds of new things to the table. But partly the change in the court is who's not there anymore. And, for Justice Jackson, it will be, gosh, we'll look around the room in a few weeks and Justice Breyer won't be there. And that would be an incredible change for the court. And similarly, when I got to the court, I wish I had thought more. It's not just like, oh, now I was there and I hadn't been there before. It's that Justice Stevens wasn't there. And the Justice Stevens had been on the court for 35 years. And it was an enormous change on the court, whoever I might have been, just not to have his presence. And so much of that time, it had been as senior associate justice. So always the second person who spoke after the chief. So it was a big change for the court. I'll say one last thing about Justice Stevens, which is the best advice he gave me, which is, when he was no end of generous to me. When I succeeded him, was just lovely in every way and offered his help and assistance in every way. But the one thing that he said to me that I try to live by, I'm sure not as well as he, but that I think about all the time. So remember, this is a 90-year-old man talking to me and a person who had been on the court for 35 years. And he said that the thing that he made sure to think about all the time, every year, every month, every week, was that there was always an opportunity to learn something new. And that's a great way to approach pretty much any job, but it's also a great way to approach being a justice, that, you can get kind of into, you're sort of doing the same thing and you can do it the same way. And Justice Stevens he was a learner. And, there was a real there, but there was also an open mind and a commitment to continuing to learn and continuing to profit from your colleagues and to profit from other people around you and to dig deeper and do better.
You've been talking a little bit about the role of courts in your answer, and many of our faculty and alumni have shared with our students the value of clerking for a judge or justice and the ways it's shaped our careers and understanding of the law. As we talked about, you had the opportunity to clerk for both Judge Abner Mikvah and Justice Thurgood Marshall. And I'd be curious what you learned from those experiences and how have those clerkships influenced your approach to serving as a Supreme Court justice?
Well, I learned a ton, and I'm sure in various ways they did influence my approach to doing what I'm doing now. But I guess I should start just by sort of a caveat, which is, I'm a different person. These are different times, facing different questions. So I never had a sense like I had to replicate either one of them. And I'm sure that they wouldn't have wanted me to have that sense. But with that out of the way, these were two very important people in my life. Judge Mikvah is not as well known, although maybe in this city, he's known pretty well because he was a Chicagoan. And he was probably the greatest mentor I've ever had when I look back over the course of my career, and it's been pretty lucky. And, there were a lot of things that I wouldn't have gotten to do, except that Abner Mikvah helped to make them happen. I think he helped me to get my first job at the University of Chicago. After I got tenure at the University of Chicago, he asked me, at that point, he was counsel to the president, and he asked me to come to the White House to work for him again. That was an enormously important experience in my life. So he was probably my greatest mentor. He was a person who I learned a lot from. I guess the one thing I'll mention, I think he understood government better than almost anybody I can think of. He was a congressman from the Hyde Park district of the city of Chicago. He was a judge and a chief judge, and then he became counsel to the president. So he served in these very important capacities in all three branches of government, and had a better understanding of how each of those branches and all of those branches work together to create our more perfect union. So I think my interest in administrative law, which you mentioned, a lot of it came from him. Justice Marshall, I mean, was the greatest privilege of my life to have clerked for Justice Marshall. He was the greatest lawyer of the 20th century, I think, bar none. And partly you can measure that in sort of like, what did he do? You know, so I mean, lawyers like this don't actually exist anymore. This is a man who argued many cases to the Supreme Court, won most of them, but he was not just an appellate lawyer. He was a great trial lawyer. So one day he would be up at the Supreme Court, and the next day he would be in some, you know, country courthouse in Mississippi trying to get an innocent Black defendant off of death row, or prevent him from getting onto death row. He had an incredible range in terms of his lawyerly skills and abilities. But of course, I mean, the key thing was, you know, what makes the greatest lawyer of the 20th century? It's like, how much justice did you do? And he did more justice than anybody. And, you know, the eradication of the Jim Crow system of segregation had, of course, many people who contributed to it, but nobody more, no lawyer more for certain than Justice Marshall. He was, I mean, he was a great storyteller. So it wasn't as though when he became a justice, he closed this part of his life. In fact, he's one of the few people, I think, maybe the only person who what they did before becoming a justice was more important than what they did as a justice. And he was a good justice. It was just that he was an extraordinary lawyer who did quite extraordinary things to promote justice in America before he became a justice. And he used to tell stories about his life and about the work he had done. Sandra O'Connor has a very neat piece that she wrote. I'm not sure when he retired or when he died, but it's a piece that talks about Thurgood Marshall telling stories in the conference room and reminding people of the importance of certain of our constitutional commitments. And for sure, that was something that I got out of that year. And because of his experience, he was the kind of justice who, you know, had a very ingrained sense that the law on the books was not always the law in practice, and that you had to think about law as making a difference in the way people lived and how it made a difference in the way people lived, which sometimes is not what you might think just by like looking at a sterile page. And I think that that's something that I also took away with him and continue to think about as a judge.
So as we talk about the things that you value as a justice, you know, you made remarks this week about questions about the importance of judicial legitimacy. Public opinion polls suggest declining trust in our Supreme Court. And so I'd love your perspective on what's driving that mistrust, and also what are effective ways of building stronger public trust in our judicial institutions?
Well, I have been talking about this a bit. I started in a session like this that I did at the Ninth Circuit Court of Appeals early in July, and then I had occasion this week to talk about it again. But let me start with something that maybe I haven't said quite as much, which is just to make clear a little bit what I mean when I'm talking about legitimacy of the judicial system, of the court in particular, and why it is that it's important. And what I emphatically do not mean is whether the court's opinions are popular. Sometimes the court's opinions are not popular, and sometimes they, you know, and the court shouldn't be doing things that are popular. I mean, part of our system of judicial review is that the court tells the majority when the majority has transgressed the Constitution, and those decisions are often going to be unpopular. So if a majority of our country thinks it's a really good idea to suppress the speech of a minority of our country, I mean, it's the court's job to say no. And that's likely to be an unpopular decision, but it's the court's job to say no. So I'm not talking about the popularity of particular Supreme Court decisions. What I am talking about is what gives the people in our country a sort of underlying sense that the court is doing its job, and when is a court legitimate? I would say it's when a court is legitimate when it's acting like a court. A court does not have any warrant, does not have any rightful authority to do anything else than act like a court. It doesn't have authority to make political decisions. It doesn't have authority to make policy decisions. Its authority is bounded, and the court should be constantly aware of that, the constraints on its authority, the bounds beyond which it shouldn't go. When courts become extensions of the political process, when people see them as extensions of the political process, when people see them as trying just to impose personal preferences on a society, irrespective of the law, that's when there's a problem, and that's when there ought to be a problem. So, what makes a court legitimate is that the court is acting like a court, is doing something that's recognizably law-like. And that's when a court will build up some reservoir of public confidence and goodwill. And as to why that reservoir of public confidence is important, I think it's just a sort of critical component of a rule of law system. Why is it that people respect the court? Why is it that people comply with its judgments? It's not because they agree with everything the court does. Presumably it's because they have some understanding that even if they don't agree, that the court is doing its job, that the court is performing this critical function in a rule of law society and a constitutional democracy. And so, and so that's the importance of legitimacy, I think, in the country today.
Thanks. And tell me a little bit more then, because you've been talking a lot about a court acting like a court. What does that mean to you?
Yeah. Well, it's a complicated question, and I'm sure different people would answer it somewhat differently, and there's room for disagreement on this score. But I would say, three things above all else. Maybe if you push me, I might add a few things to the list. But I would say three things above all else. The first is that the court abides by precedent, except in unusual circumstances. So, precedent, in one opinion, I called it the foundation stone or a foundation stone of the rule of law. And it is. It's what creates stability over time. People rely on the law, and people know that they can rely on the law. It's a doctrine of stability. It's a doctrine of humility. It's a doctrine that says, individual judges shouldn't come in and just think that they know everything, that there's a kind of built-in knowledge that happens over time and that judges should respect and defer to, again, except in highly unusual cases. Most important, and when we're talking about legitimacy of the court, it prevents people from thinking that it's all about politics. What if a new judge comes in, if there's new members of a court, and all of a sudden everything is up for grabs, all of a sudden very fundamental principles of law are being overthrown, are being replaced, then people have a right to say, what's going on there? That doesn't seem very law-like. That just seems as though people with one set of policy views are replacing another. So it's a doctrine that prevents the court from looking like any other act. Like when one congressman replaces another congressman, well, you expect them to have different views and different outcomes. Not so, I think, with courts and with law. I would say the second thing is to have methodologies that constrain you and to apply those methodologies consistently. And the second being quite as important as the first. I mean, what is it that separates law from politics? It is a sense of constraint. It is a sense that judges can't do just whatever they want. They can't implement whatever personal, social, political, policy views they happen to have, but they're bound by their role to fairly apply, fairly interpret and fairly apply the law. And to do that, they have to have methods of one or another kind that constrain them. And they have to apply those methods consistently. So if you're a textualist, you're not a textualist just when it's convenient. You're not a textualist just when it leads to the outcomes that you personally happen to favor. You're a textualist when it does, and you're a textualist when it doesn't. And so too with any other methodology that's intended to constrain the role of judges. And I suppose the third thing is just a commitment not to do what's more than you have to. So Judge Friendly, great appellate judge, had this line which said, when it's not necessary to do more, it's necessary not to do more. Which maybe I've a little bit misquoted, but you get the idea. And that, I mean, what he was expressing was a commitment to incrementalism, commitment to minimalism, if you want to use that term, a sense that the law shouldn't proceed by leaps and bounds, that it should proceed incrementally and building on what has come before. And a sense that when the court gets involved in things that it doesn't have to, especially if those things, are very contested in a society, it just looks like it's, spoiling for trouble. It looks like it just wants to decide those matters, even though it doesn't really have to, given the case before it. So that makes people, again, rightly suspicious that the court is doing something not particularly court-like and law-like.
So I'd like to follow up a little bit on some of the threads of that answer. You've long talked about the importance of stare decisis, right? And we were just talking about the importance of precedent now. And your approach to cases has been consistent with this view of the law you were talking about in your third point of it evolving over time in a more subtle fashion. Why do you think that stare decisis is so important? And how do you identify the rare instances in which a rejection of precedent is needed?
Yeah, I have been talking about this for a long time. Partly I owe many things to Justice Scalia. He taught me a lot during the time that we spent on the court together. But one thing he did for me was actually to give me an opportunity pretty early on in my tenure on the court to write about stare decisis. And he did it because there was this case that came to us, and it was called Kimball v. Marvel. And most people know it as the Spider-Man case because it was a patent law case, and it was a crazy kind of case. It was a patent for this piece of Spider-Man equipment, like a toy for kids, where you put on a glove and then you went around casting webs, And the question was who had a patent for it. And so when most people talk about this case, it's about Spider-Man. And I have to say, maybe I encouraged that a little bit because my opinion has some Spider-Man things in it. But it's actually a pretty serious case, and I think has some serious things in it. And the reason I say gratitude to Justice Scalia is we went around the conference table that day, and it was a divided vote, and Justice Scalia ended up being the assigning justice on the case, the most senior justice in the majority. And I guess I had spoken pretty strongly in conference, and he called me, as the assigning justice sometimes does, and he said, listen, Elena, I think you ought to write this opinion. And I said, you know, I was happy to do that. And he said, the reason I think you ought to write this opinion is because it's kind of a statement opinion. And I said, well, what do you mean by that? And he said, you know, there are only so many times that a case comes along that you can really tell the world what you think judging is all about. And, you know, what you said at conference today, I think you have something to say about what you think judging is all about. So that's what I did. So I'm very grateful to him for that. And I wrote this opinion, which was about the importance of stare decisis, and talks also about when it is that stare decisis can be overcome. And, you know, it basically says stare decisis can be overcome when there's quite significant change that makes an old decision not appropriate anymore. Sometimes the doctrine has changed all around one particular holding, so that the holding is kind of like an island in a sea of something else, and it's just become incongruous given the way legal doctrine generally has developed. And the court has like a whole, most of this was not, you know, it was not original to me. I mean, I was drawing on a whole body of doctrine about when it is that stare decisis can be, overturned or dismissed or whatever. So this was like totally not original. I was building on this whole body of doctrine, but that's one example. Another example is when you've discovered that the doctrine that the court has created is entirely unworkable, is usually the expression, is unadministrable. So that's change of a different kind. It's like, you know, the change that's happened is that a complete mess has been created, and the court has to deal with that in some way. And then sometimes the change is less legal and more sort of social and attitudinal, that we live in a different world. You know, it could be not even social or attitudinal, it could be technological, right? We live in a world where technology is different, but also we live in a world where the sort of social facts of life and attitudes are completely different. So one example of this is, you know, there were all kinds of decisions about gender equality that read decades and decades after they were announced. You realized you couldn't make them work in the world we lived in any longer. So I think most of these things pretty much, I'm not saying 100% of the time, but a very large percentage of the time, you get to overrule a case when some significant change has occurred, and you don't when it hasn't. And as to, again, why that's important, I don't want to repeat myself too much. It's important to make sure that that it's not the personal proclivities of judges that are driving decision making. It's important to ensure that the judges are appropriately respectful of what's come before, and it's important to give people a sense that law is continuing and stable, and they can rely on it.
So I'd love to follow up on that with a question that sort of looks at the procedures of the court. And in particular, you and Chief Justice Roberts, and as well as other justices and commentators, have raised concerns about the increased use of the Supreme Court's emergency docket to raise legal issues. What do you think is the appropriate use of the emergency docket?
Yeah, I think this actually is a facet of what I talked about before, of the court, you know, not going out of its way to be involved in things that it needn't be involved in. And in this case, I think shouldn't be involved in. So the emergency docket, I mean, there was a time when the emergency docket is the term that's often used for this sort of court deciding something without full consideration by other courts, and particularly by a court of appeals. and without full briefing and argument. And way back when, like when I was clerking, the emergency docket was just something that you used for capital cases. When there really was an emergency, somebody was about to be executed the next day, and there were legal claims to be heard, and you couldn't run it up the flagpole in the typical way that you can. So that was an emergency. And there are definitely times, and certainly there may be times outside that context where there are real emergencies where you just can't do the kind of step-by-step judicial decision-making that we would like. But that step-by-step judicial decision-making is of crucial importance. I mean, it exists for a reason. It exists because people think, and they're right to think, that the Supreme Court makes better decisions when other courts have made decisions before it. And when it gets a chance to look at well-reasoned or even poorly reasoned, for that matter, opinions by lower court judges, and to see how they've considered a problem. And then that there's better decision-making when the court itself has time to consider something, when it doesn't do something on preliminary papers without argument, but when it has full briefs, when it has the chance to hear argument, when it has the chance to think about it some. I mean, from your ordinary life, you make better decisions when you have more time and more inputs. And that's the problem with the shadow docket or the emergency docket, and why it is that it should be kept for pretty rare circumstances. Again, there are those circumstances, and there have been some recent issues that really have brought this to the fore, and I think made the court more likely to use this form of decision-making, which I understand. In recent years, some district courts have issued nationwide injunctions, and this happened in the Trump administration, and it has also happened in the Biden administration. So this has no political tilt to it, but some district courts have very quickly issued nationwide injunctions to stop a policy in its tracks, that something that the president and or Congress has determined to be the national policy, and one district court stops it. And then you combine that with the ability of people to forum shop, to go to a particular district court where they think that will be the result. And you look at something like that and you think, well, that can't be right, that one district court, whether it's in the Trump years, people used to go to the Northern District of California, and in the Biden years, they go to Texas. And it just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through normal process. But I think that there are ways, even in circumstances like that, where we're not just doing it like super fast without any consideration by other appellate courts, without any argument. I mean, I think, processes can be adjusted to deal with situations like that, but we have to keep in the front of our heads the importance of full deliberation. And we have to keep in the front of our heads, again, just this sense of, just because we think, oh, that's wrong, it's not necessarily, all the time when we take cert on a case, people will give preliminary views of the merits. And it turns out that the preliminary views of the merits, they sometimes hold up, and then again, they sometimes don't. Turns out that, greater knowledge, greater time can change people's instinctive senses of what's wrong. And we shouldn't be so quick to just say, they got it wrong, we can change it.
So I want to go back to a thread of your answer on judicial legitimacy. You famously said in 2015 that we're all textualists now, but you more recently questioned the accuracy of that statement. What do you understand textualism to mean today?
So when, let me give you a little bit of context of when you said I more recently questioned the accuracy of that statement. I had, in a conversation much like this with the Dean of Harvard Law School, I had talked about how, we all, or most of us, honestly, not Justice Stevens very much, and not Justice Breyer very much, but I would say most of us put a great deal of emphasis, or say they do, on the text of statutes. And I'll tell you why I think that's important in a second, because I'm happy to think of myself as a textualist. But what I was saying recently, this was in a dissent that I wrote in just this last June in a case called West Virginia versus EPA. And the question was whether the EPA had sufficient statutory power to respond to climate change in a way that the EPA wanted to. And I thought that if you looked at the text of the statute, it was pretty clear that, take out the word pretty, it was clear that the EPA had such power under our normal textual rules of interpretation. And the majority said, well, there's something called the major questions doctrine, and that kind of trumps our ordinary views of statutory interpretation and our ordinary commitment to textualism. Because when there are major questions that an agency is answering, we're just going to presume that an agency doesn't have the power unless Congress does something special, unless Congress makes its opinion more clear than it usually has to, or more specific than it usually has to, something like that. Now, what is a major question? Who knows? The majority thought that this one was, but if the point of a doctrine like textualism, which I take it is the point of the doctrine, I think that this was, Justice Scalia was probably the most famous textualist, and I think he thought that this was the point of the doctrine. It was to constrain judges. We just talked about this. It's that constraint on judges is a critical part of our rule of law system, and that judges can't be rewriting statutes to fit what they would want to do. Maybe each of us has a view of what statutes we would like, and it's different from the view of what statutes Congress has decided it likes, and different from the statutes Congress has enacted. And the point of a doctrine like this is to make sure that judges aren't rewriting statutes to conform to their own policy preferences. And basically, in West Virginia, I sort of said, well, that's the point, and so we shouldn't have this kind of major question exception to textualism that allows a court to say, yeah, we're not really all that comfortable with this kind of environmental regulation, or we don't really like agency action very much. We're not real big fans of regulation, and so we're going to set up new hurdles. And similarly, I wrote a dissent a few years ago. It was a little bit of a different context, but where I guess it was the year before this past one, where the majority had interpreted the Voting Rights Act in a way that I thought just was not consistent with what the statute said, and again, departure. There's a kind of malleability that I think people should be concerned about when courts sort of have leeway to rewrite a statute.
So another sort of trend line in the evolution of what's going on in jurisprudence in the court right now has been the increased reliance of the court on originalism as an interpretive methodology. And this, obviously, there's a lot of contestation both in the courts and also in academia about originalism. And so I'd love to hear your perspective on how you would describe originalism, and when and how do you think it should be applied?
Well, I guess I'm not quite sure how to describe originalism as the strongest proponents of originalism practice it. I mean, I think what originalism has looked like in recent opinions varies, seems to have a kind of flexibility to it along all kinds of dimensions. What period are we looking to? What time period? What evidence do we look to? How general or how specific does the evidence have to be? Seems to be sometimes there doesn't seem to be a clear answer that's consistent across all cases. What exactly are we looking for? Again, I mean, the claim, I think, is that we're looking for the original public meaning of a constitutional provision, but it's not clear how that relates to just what you might call traditions, practices that were prevalent when the constitutional provision came into effect, as opposed to people's understanding of that constitutional provision. So I think that there are lots of questions that seem to have indeterminate answers. And so, part of, I guess, my thinking about originalism is, I'm not sure what it means, given that it seems to be sort of fluctuating over time and over cases in ways that, again, makes you concerned that the rules change as the desired outcomes change. I mean, I think looking to original meaning is something that judges should do as a piece of the puzzle. But that it's likely, for me, not to be the dispositive piece of the puzzle. It's relevant, but it's likely not to be dispositive. And I guess I would contrast this a bit to textualism. I mean, textualism, often there are not clear answers when you do statutory interpretation. So textualism is not kind of, all you do is you read the statute and then you're done and you shouldn't do anything else. That's not the kind of textualist I am. I don't think it's the kind of textualist many people are. I mean, you are done if the statute is clear, but there are lots of times when the statute is not clear, and then you look to other things. And hopefully you look to them in ways that are themselves principled and disciplined, all right? But I think when it comes to constitutional provisions, there is much less determinacy. I mean, there is, number one, it was just a long time ago. And, it's hard to figure out what people thought a long time ago, what things meant a long time ago, what people did a long time ago. I mean, historians know this. All you have to do is look at some of our recent opinions to know that there's an enormous amount of historical evidence and that it's cross-cutting. You look at our more recent and our less recent gun cases. Heller, where Justice Stevens wrote the dissent and Justice Scalia wrote the majority, and then the more recent gun case, which was Justice Thomas and Justice Breyer. And they all bring evidence to the table, right? And you look at it and it's kind of like, okay, how do you figure that out? And law is committed to finding an answer, right? But it's just not clear you can find an answer from that kind of evidence. So partly, I think, originalism does not work so well because it was long ago and it's hard, all right? But partly, like originalism, as some of my colleagues understand, it doesn't work so well because it's just inconsistent, I think, with the way the Constitution is written. I mean, when the Constitution says you have to be 35 to be president, okay, we can all agree that that's what the text says. And so we should all say you have to be 35 to be president. And I'm not in favor of any of these like methods of statutory interpretation that go, well, 35, it meant something different then, maybe, maybe now it should be 30. I'm not in favor of that at all right? But a lot of our Constitution is not like that. A lot of our Constitution is, a guarantee of due process of law, a guarantee of equal protection of law. That's from the 14th Amendment, but the original Constitution also. I mean, they knew that they were writing for the ages. They knew in Justice Marshall's phrase that this is a constitution that they were expounding. The Chief Justice Marshall. And so they wrote in broad terms. They wrote in what you might even call vague terms. And if you look at that, you think they could not possibly have thought that 250 years later, people would well, what exactly did they mean when they said equal protection of the laws? I mean, they didn't list specific practices. They used that term, or any of the terms from the 14th Amendment or from the original Constitution, those sort of generalities for a reason, because they knew the country would change. And my gosh, if there was anybody who knew about change, it was the original founders and the framers of the 14th Amendment. They knew all about enormous changes that happened in their lifetimes. And they knew that a constitution was meant to survive for the ages. And so, I guess my view, I think I once said, I seem to have a kind of weakness for these phrases. I once said, not just we're all textualists now. I once said we're all originalists now. But I actually said that in my confirmation hearings, so that was about 13 years ago. And I'm quite sure that if you went back, because I recently did this for myself, that's why I'm so sure. If you went back to my confirmation hearings, when I used that phrase, I was saying exactly what I just said to you. And when I said we're all originalists now, what I was saying is that the way I kind of understand originalism is like, okay, when they say you can't be president until you're 35, you got to take that as a given. But when they say, all the many broader, vaguer, more, statements of principles, again, whether coming from the original Constitution or from the 14th Amendment, when they say that, you sort of have to take them at their word that they didn't want, like the specific set of things that were true in 1789 or that were true in 1868, that they had some understanding that life would change and that you were supposed to apply these principles, and you had to apply these principles, but to circumstances that they couldn't imagine.
So I've really appreciated your sharing all of these insights with us today. And we have so many more things we could talk about, but I think we're just about out of time. So I wanted to just ask you one last question, which is that I, as a dean, often say that our law students give me hope for the future. And so I'd love to hear the advice that you have for our next generation of lawyers and legal professionals at this moment in which the importance of rule of law could not be clearer.
Well, I guess I'll talk to law students. This is a law school, and I used to think about this question a lot when I was in your shoes, and I guess what I always wanted to say to a group of risk-averse people was to take risks, to not follow the path that just in law that everybody else follows just because everybody else is following it. That the most important thing you can do in a legal career for yourself and for the society around you is to find the thing that gives you a sense of purpose and meaning in your work life. And that's going to be different for everybody, but that both for your own personal satisfaction and for the greater good of our country, to find what it is in law and what kind of work in law you should do, so that every day you wake up and you think, I know why I'm going to work. I'm doing something that I think is important. I'm doing something that has meaning, and meaning, for people outside yourself. I'm doing something that has a real purpose and point. So I guess that's what I would say.
Well, Justice Kagan, it's been such an honor to have you here as the Howard J. Trienens Visiting Scholar. Thank you for sharing this wonderful advice.
Thank you very much. Thank you. Thank you very much. Shall we? Thank you.